March 21st, 2016. Sitting on our panel today, myself, George Azunian, Chairman, William McKinley, and Matthew Graham. Alternates present are Glenn Fowler, and Lance Morris is not here. So, going to our agenda, board members, any comments from the board? Okay. Comments from staff? Okay. Comments from assessor? No comments. Boy, we're really moving along here this morning. One of the issues that we kind of noticed this morning is that next June, on the 16th, we have an Assessment Appeals Board scheduled for Thursday instead of Monday, and that's at 1 o'clock. Okay? And I understand that the Board of Equalization requires us to have our July meeting on a Monday, the 18th, third Monday. Question is, do we want to do 1 o'clock or 9 o'clock? It's kind of to our discretion. The Board of Equalization only requires us to meet on Monday once a year. What do you prefer?
We have no preference.
Okay. And staff?
I don't know what the availability of the room is my only concern.
We're going to leave that open until next meeting to decide?
Yeah.
Okay.
It's available.
It is available? Okay. I think.
Okay. So we'll kind of reconfirm that next meeting, which will be on June 16th, which is a Thursday, 1 o'clock, and then we'll reaffirm that date.
And I'm going to prepare an agenda item for the Board of Supervisors, because I did find something, too, that indicates that even though the board, the Assessment Appeals Board can make these kind of changes, then they're subject to ratification or approval by the board.
Okay.
So I'm not 100% sure this falls under it, but in an abundance of caution, I want to
Okay.
just do that agenda.
Any comment from staff or the board members? Nope. You okay? Yep. All right. Okay. Then we'll move to agenda item number 2. These are all issues of timely filing. First one, agenda 2, is Lactus America Group, and Jason Morris here. What's going on there?
This was just brought back for clarification.
So the issue with this, if it was continued from last meeting, was a different issue than the case that they had regarding the plant.
Correct.
Refresh our memories on what this was about.
This was about timely filing. They had
And
filed.
why wasn't it timely filed?
They filed in Fresno
Now I
and
remember.
brought it back to Tulare County.
Yeah.
And this is the one where Mr. McKinley pointed out that in the Assessment Appeals Manual, there is guidance that if it's filed in the wrong county, that it should be deemed timely here, or it can be deemed timely here.
So
Yeah.
if that's the case, then we'll bring it to the board.
You know, the board this time is Fowler and Matthew, right? Fowler and Graham.
McKinley and Graham.
No, Fowler and Graham, isn't it?
Today it's
Fowler and Graham on this one.
Because the original panel was Glenn Fowler and Matthew Graham.
Okay, you're right. So, Glenn and Matt are up for considering this to be timely filing.
If you would like me to read the guidance from the manual, I can do that. I have the section right here. And so it says that application timely filed in wrong county. Subdivision E of Section 166 expresses the legislature's intent that its provisions are to be, quote, liberally construed in favor of the taxpayer, end quote. Consistent with that intent, a timely filed application unintentionally filed with the appeals board of another county may be deemed to be filed within the specified filing time. And then there's some more, but that's the basic of it. And this doesn't really have, it's not a legal authority in the sense that it's a a statute or a rule, but it does say that you can consider it as sort of as guidance, and even courts would take it, into consideration that you had relied on this.
Right. I'm going to let the two of you speak first, but I'll just reiterate that we have always, since I've been on the board, have given whatever latitude we can to the taxpayer. And that's what this is really all about, is giving them the latitude of considering it to be a timely file, but that's going to be up to the two of you, whoever wants to make a motion one way or the other.
I'll make a motion that we continue this.
Continue it, or you want to decide it?
Well,
You want to consider it timely, and then they'll schedule it.
okay, to consider it timely, and because it was filed in the wrong county, I don't feel it was taxpayers.
And just to clarify then, if we consider it timely, then we get to hear it, right? Is that the next step?
That's a good point. In other words, who gets to hear the case? The timely filing doesn't affect the case, does it?
No, it's a completely different
So
matter.
it could, whoever's on duty at the time that they bring it to us.
So, you want to consider it timely? Is that what you're saying, or you want?
I would consider it timely because it was filed in the wrong county. It was an error, and the taxpayer should be able to benefit to continue on.
And that section gives us the ability to do that, correct?
Right. This is guidance from the Board of Equalization. It's like I said, it's not a law, so it's not a set in stone. But this is their interpretation of the law and their, the guidance that they give to the
I would
boards.
second that motion.
Okay, so we have a motion and a second. All in favor of considering this to be a timely filing signify by saying aye. Aye. All opposed? Hearing none, it carries. Okay, the agenda item number 3, Milo Hospitality. Someone here for them?
Yes, my name is Robin Ho.
Well,
Good
wait,
morning.
Just a second, sir. We're going to swear you in, and the assessor and you will be sworn in by the clerk, and then you can state your name then.
Okay.
Do you solemnly swear or affirm that the testimony you're about to give in the matter now pending before the Assessment Appeals Board is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Please state your names for the record.
Good.
My name is Robin Ho. I'm one of the members of Milo Hospitality LLC.
Need more?
I'm going to go ahead and write in the APN number.
Yes, go right ahead.
APN number 990-248-987-000.
Okay, this is a case regarding timely filing. Has nothing to do with the evidence of the case if the board decides to hear it. But for some reason, evidently, your filing was late, and that's what you're here regarding. So can you give us the basis or facts that regarding why you were late?
Yes, Honorable Chairman and the board and the assessor. We heard my petition in the last hearing, but let me just briefly summarize to remind you where we were when we adjourned last month. We filed our petition late because the notice of supplemental assessment that came to us, the mailing address bear an incorrect zip code. I did not receive that notice. I did not receive that supplemental assessment until after the deadline for filing. However, I filed my petition immediately and see
When you got
relief
noticed.
from the late notice. When we adjourned last time, time was given to the assessor's office so the assessor could verify how did that incorrect zip code came about. And after I went back to my office, I did some search myself, and I discovered that when we acquired the property on the grantee, which we did not prepare, we received that from the seller. The grantee bear the incorrect zip code 91106. However, on that same day and recorded immediately after the grantee, there's a deed of trust that we executed, and on this subsequent document on the channel title, our company requested the tax information to be sent to the correct address with correct zip code. So I can only speculate the assessor's office having the incorrect zip code was based on a previous recorded document.
Okay. Did you have a comment? Did you want to make a comment?
I was just going to try to refresh the board's recollection about last month's.
Right. He what?
I was going to try to save him some time, but it's fine.
So you presented it again.
Okay.
Does the assessor have any objection?
No, actually we don't. He's correct. Both the grant deed and the preliminary change of ownership that they signed and filed did have the incorrect zip code on it. That's what we based it off of, is what was on there. But we were notified later of the correct zip code. However, that did not get input in time for his supplemental bill. So his supplemental bill did go out with the wrong zip code.
So again, from council, we have the authority to determine this to be timely.
I believe so because he didn't receive it, in the normal course. So
Right.
he filed
Okay.
it within the time after he received it, as far as we know.
Okay.
Hard to determine, but I think that that's fair.
All right. Mr. Fowler, bring it to you. I mean, Mr. McKinley.
This was also Mr. Fowler and Mr. Graham last time.
Oh, it was the same thing again. Oh, so I was right.
I'll make a motion that we can go ahead and hear his case,
Consider it timely.
consider it timely.
I'll second that.
So we have a motion and a second to consider your filing to be timely. And now the clerk will schedule it. When do you want your case to be heard? Next month, 2 months? Have an idea?
No,
We'll have to put it on just like any other application, and then he'll get a 45
In other words,
day.
will it be next month?
No, it won't be next.
Okay. They'll notify you as to when the date is. Okay?
Thank you very much.
much.
Are you going to call for a vote?
Oh, yes, I'm sorry. We have a motion and a second. All in favor signify by saying aye. Aye. Here, opposed? Hearing none, motion carries. Thank you very much.
Thank you, Chairman. Thank you, the board.
Okay, we're down to agenda item number 4. This is also a timely filing case. Is there, this is Rogelio and Joandrew Ortiz. I probably butchered that name, and I apologize. Are they present? Okay. Again, the clerk will swear you in.
You solemnly swear or affirm that the testimony you are about to give in the matter now pending before the Assessment Appeals Board is the truth, the whole truth, and nothing but the truth? Speak into the mic.
Well,
Yes.
yes.
Okay.
Please state your name for the record. State your name for the record.
Oh, I'm sorry. I'm Rogelio Ortiz. I live in Porterville since 72. I live in 1370 West Jean Avenue, Porterville.
Okay.
My name is Joandrew C. Ortiz.
I'll go ahead and read in the APN numbers.
Okay. Go ahead.
APN number 215-141-015-000 for 2011. APN number 215-141-015-000 for 2010. APN number 215-141-015-000 for 2009. APN number 215-141-015-000 for 2008. APN number 031-002-000. APN number 206-031-002-000. APN number 246-271-018-000. APN number 246-271-018-000. and APN number 251-221-003-000.
Okay, this case again has to do with timely filing. Nothing about the case are we going to go through except the filing date. So can you tell us why you believe it should be considered timely even though you filed it after the date that it was due?
Well, we didn't receive no statements in the mail. So what we did it always, we went and pay. Like let's say in 2008, we went over there and says, okay, how much was the taxes? 12,000 something.
Right. Okay. So in other words, in effect, that's really, what was the reason it wasn't filed correctly? Because you didn't get noticed and didn't see what was actually transpiring timely?
Well, we didn't see the bill that you guys that they sent to us.
Right.
We came, how much we owe them, says 12,000 something.
Right.
We pay them.
Okay, the main reason here is because we think the value of the properties.
Oh, that's fine. What I'm trying to get at is that the date that you filed, how long were you late from filing?
How long will it could be?
Since
Several years, huh?
yeah.
Oh, several years.
Yes.
Okay.
This is 5 cases, 6 cases. We cannot.
No, I understand. Basically, what we have to do is we have to decide timeliness, then we'll hear the case if the board decides to accept it. But if it was actually a couple of years from the time you were supposed to file to the time you did file, is that correct?
I don't know if I'm saying right. I went and paid them, and I didn't see the bills of each house.
I see.
And then we paid about 12,000 something, and then 2008, and then 2012 we went over there and we paid about 11,000 something. We didn't see nothing, and then everything started after we got another case in Strasbourg. Then now. You guys in trouble in court. I demand for 475,000.
Right.
Because I says
well, in effect, basically, then let me ask Mr. Assessor Lee what you considered to be the facts as far as timeliness filing.
These are all well out of statute. Some go back to 2007, and these are annual assessments, not escapes or supplemental bills.
Okay, so in other words, taking the issue of just filing, did the applicant pay their taxes?
Yes, and he should have received statements at his address that he provided us in 2000. He would receive his annual statements.
He paid them timely?
Yes.
Okay, so as regarding payment, you got noticed, and you paid them?
well, we don't get notice. We came.
No, I'm saying you must have come for some reason. In other words, did you come to pay your taxes because you knew that they were due on the due date, or did you come because you got billed?
No. I came to pay ourselves, me and her and me. What I didn't see, what I didn't like is that 2006, the volume went double.
All right.
I mean, that's ridiculous.
Well,
Double.
and what I'm trying to say is that the doubling of the amount, that caused you to file the assessment.
Yeah, because later we didn't see that resist. Number one, I trust United States. It's number one. Then after we got a little details in Strasbourg, I told her we better look. Let's see what's going on. And what we see is that he charged to us 2006 double the amount.
Right.
2006, 2007, double.
You know, in effect, and I'll just tell you that I saw my property taxes, has nothing to do with this, automatically go down. The next economy picked up, it automatically went up. I didn't notice them, they didn't tell me that they were going to do it. It just came in as a notice. So if we're talking about 2006 and it doubled, that doesn't seem like it would be all that unusual, but in effect, you didn't file a protest at that time. Is that correct?
Yeah, because we didn't check.
You didn't check.
We didn't pay attention on the
We didn't pay
buildings.
attention. We didn't check. Plus, some houses didn't have no foundation.
Right.
The assessor people only goes like if it's his own property, goes over there and boom, 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 you owe so much.
I understand.
Even the yellow man over there, the one that black and white, he bring me the drive around. Remember, you give me the drive around. Hey, where I go, you go here. Where I go, you go there. Where I go, you go there.
Well, there may have been one side or the other. I'm just speculating that maybe there's communication issue.
No. I give him really the communications.
Okay.
But see, once you go over there with assessor, like I'm working in the fields, I'm a self-employed, I know over there, all the fields, I know the fields. But in the assessor, only I go and pay him, and that's it.
Right.
And
Well,
let me say something for the record, okay? Most of the people has a lot of big issues at home. Like, for example, in my case, my second son has autism. So for me to be very specific on the papers and leave my son on the side, that will be kind of difficult. But when you get something very strong, that's when you have to pay more attention,
Right,
and then
I
you have to
understand.
go through all the houses.
I
May I
understand.
ask-
I'm going to bring it to the board. Go ahead, Mr. McKinley.
Go back to the assessor now. These are escape assessments?
No, these are not escape assessments, not supplemental bills. He is contesting his annual assessments going back to 2007.
Okay,
All well-
and when-
all well out of statute.
Yeah, okay. When did you file the petition to have this changed? When did you file these papers?
Probably about what, 3 months ago, 4 months
Yeah,
ago?
that was last year in November.
But see,
October, November.
we file.
It says
we went over
11/21
there-
of 15, is that right?
Yes.
Yes.
Okay. Did you receive, you obviously received the bills and paid the bills to the assessor. Is that right during this period of time?
Well, in that time, yes. But when we make our eyes open, is another house in Strathmore. There's almost the assessor tried to sell them. Well, I don't know, tried to sell my house for. It's a renter for I guess for $12,000, and then that opened our mind. And I said, we better go and see what's going on. And we see the assessors, like he says, even the houses, they don't got no foundation. It went double, like 50,000 to 100,000, 75,000 to 150,000. I mean, how can you?
Yeah, it's not the values I'm worried about right now. Would you tell me, counsel, what is the normal time to file a petition on a regular assessment?
I believe it's by November 30th of,
How much?
November 30th after the assessed date.
Okay, so it would be in, so if it was filed after November 30th, it was late.
Right.
Chairman, I move that we deny this motion.
Okay. We have a second?
I'll second that.
Okay. We have a motion and a second to deny your application timely. And all in favor signify by saying aye. Aye. All opposed? Hearing none, it carries. Now, I will tell you that I believe you have the right, and you should discuss with the assessor, if you want to file this year based upon what your taxes are. Instead of going back to 2007 and reconsidering all of those years, you, I believe, have the right to file again timely and have them consider the value at this time.
What I can do is sue him again. Let's see how much we have to pay to his lawyer, and how much I pay. Because like I say, I already have a case filed in Porterville for $475,000.
What did you file in Porterville?
I filed a house that these people did wrong too. That's it. I already filed in court in Porterville for $475,000 because these people don't even listen to me, and now we have to pay you guys' lawyer and my lawyer.
Yeah,
I mean, for this one, if you deny
as much
it,
as I sympathize with you, that at this stage, now that we've considered it to be not timely, in effect, you need to decide what your best course of action is and do what you need to do. But as far as going back to 2007 and reassessing that value at those years, the board has rejected that application.
Well, I will go ahead and sue them for each property. Let's see.
You were saying, what was the case, the one in Strathmore? I'm gonna explain it a little bit, because my husband explained it very fast. Okay, that house in Strathmore, they will know. That house, it was, has a lot of violation code, okay? And under the law, they shouldn't go up on the price. And then when they want to sell it, so we have to go in Chapter 13 in order not to take the house. And then they went back. That house, they put it for $141,000 in Strathmore. And then we make all this noise. They went back and assessed that house, and they come up that the value of that property was $30,000.
Right.
2013. So, see, that is the thing that they made the mistake. They never listened to fix it.
Yes.
But they fixed it at the last minute.
Again, if you'd like to consult with your counsel or your accountant or whoever and decide what course of action you need to take now, you're more than, we'll listen to an application. What I'm trying to tell you is that we tried to listen to what all of the taxpayers, because in effect, you may not have the same knowledge as the assessor does. So from my perspective and what the board's done, we give you consideration. In this particular case, but going back to 2007 is something the board doesn't want to do. So we took action.
Oh, the house went up at 50%. It went up at 50% up. And then every house went down 50%, except the house in Strathmore. I mean,
well, the point I'm making is that we can't really hear evidence of why the assessment went up or down or what the values were. As I'd indicated to you, my own residence basically went down in value from this very same period of time. Taxes went down, and it went back up. Taxes went up. So the point I'm making is this is very normal. In effect, the assessor has the ability, depending on whether it's in an incorporated city or not or whatever, to do this automatically. That's what I don't want to get into as far as your situation as to why the taxes went up and down. That's part of a hearing. In effect, we haven't had a hearing because we didn't consider your filing to be timely. If you want to file another case and have it heard timely on the facts of the matter, you're more than willing to, or we're more than willing to listen to it.
well, we go ahead and do it. We go ahead and file in court again. Because, see, you guys, you don't hear me what I'm saying. What I'm saying that these people do it whatever he wants. I'm talking the house in Strathmore, every house went down, except the one in Strathmore. It went up, and it didn't got no foundation. I told them, tomorrow, the next day, the following day, and nobody went. Oh, we got paper here, paper here, there. I'm not the only one too that's not happy.
Yes,
you guys got a problem too with the federal. You should hear something for the federal too.
Right.
The federal is suing the county too.
Right. Well, in other words, what I'm trying to say is that that's all we could do.
Right.
We can't really do any more at this point.
So I go ahead and sue them for each house, and these people have to respond because that's what he get paid.
As long as it's filed timely.
Excuse me?
As long as it's filed timely.
Well, we'll see.
Okay.
When the time comes, we'll see. But at least I let you know what these people is doing it. At least if you know, and probably you see me later.
Okay.
And you better, if you got a power, you better tell these people to say the truth. Where did you go? Where you go? Take the guy, sir. Go here. Go there. That's what I do to my workers.
I understand. We wish you the best.
Okay. We'll see you in court what this has to.
Okay.
And you got, like I said, you got another lawsuit, $475,000 for the house in Strathmore. It's already filed in Porterville. Probably you know already. And these people should be answered to me in court.
Very good.
Thank you.
Okay, thank you. Okay, next agenda item is Jason Jackson. Mr. Jackson, this is again, timely filing case? Is that what this is, Madam Clerk?
Yes.
Okay. And the clerk will swear you in and read in the case.
Do you solemnly swear or affirm that the testimony you're about to give in the matter now pending before the Assessment Appeals Board is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name for the record,
Jason Jackson.
and I'll go ahead and read in the
Yes,
APN
go
number.
right ahead.
APN number 259-360-030-000.
Okay. Mr. Jackson, give us just a summary of why your application was not filed timely.
Mr. Chairman, if it pleases the board, I was not under the impression that the application was untimely.
Okay?
So there are a few predicaments here. The application that I submitted was for the year, I initially submitted for 2013.
Right?
The rules on the face of the documents from working offline state there's a 2-year right to appeal. So I appealed for 2013. That was sent back to me, and it was amended to 2015. So that appeal for 2015 was filed timely within this year. So if it's in regards to 2015, I have no speculation as to why it would be deemed untimely.
Okay. Well, let me ask the assessor the facts of the matter as far as filing.
Well, I'm not sure. I think the letter that Candace sent back explained it well, and I think Mr. Jackson said it himself. He was under the misconception of the 2-year time period, the 2-year time period being an application being resolved. I think that's what...
An application what?
An application being resolved within
Resolved,
2 years.
okay. Yes.
I think that was the issue. As far as if he filed for 15, I was under the impression he filed for 13.
Can we take just one moment?
One second.
Sorry.
This is the first time this has ever happened. I know Mr. Jackson.
Oh, we
so
have
I need
another
to-
issue.
I probably need to step back.
Yes.
I didn't realize it until he started talking. So should I step
In other
back?
words, what,
I have no objection.
you have no objection.
No objection.
Well, do you have an objection?
I don't have an objection. I just wanted to make sure I did it
And
right.
that goes to the assessor. Now, what was your relationship, let me just ask?
We worked together.
Are
I
you
was
a
in-
broker?
No. I was in high school.
We're talking about a number of years ago.
A number of years ago, yeah.
But you had a relationship to him at
Right.
that. Now, in effect, I'm just trying to make sure that we all understand. You wouldn't have a case, we wouldn't have a problem hearing this case timely.
Well, I mean, I think we're still hearing the evidence of that, right? So.
Yeah, but I'm saying
But
if
I
you
don't
wouldn't
have
have
an
an
objection hearing it.
objection hearing it. That goes back to the assessor. Will you have an objection?
No, we don't have an objection.
Okay.
I do want-
So we needed to clarify that in case we needed to have someone else listen to it.
I think the issue here is that the assessor's office has essentially, and this is not to be taken as a unkind comment, but the assessor hasn't communicated with me properly. It shouldn't be before the board at this time. I think this should be resolved between myself and the assessor's office.
Well, they don't have the latitude to go back and look at an issue that far back without having a case that indicates that your application was filed timely. Then you go do what you want with the assessor. That's not the issue. The issue is the case filed timely enough, or is there issues that basically allowed you to turn around and bring it to our attention now? That's really the matter.
I think what the matter is now is, what is the assessor's position?
Well, I'm a little confused on what year the application is for now. I was under the impression it was 13. If it's 13, it's definitely untimely. If it's 15, I'm not sure when he filed it. It may very well be timely, but I don't know what year we're talking about.
What year are we talking about? Because it's
The
not on the
letter that
agenda
was-
as a year.
The letter that was attached to the application that made me send the letter that it was invalid is that he was indicating 2013 and there was no mention of 2015.
Right.
So the application that he had filed had
Was
the
for
indication of
2013.
2013. If
Right.
it was for 2015, it's fine.
It's timely for
It's
2015.
timely 2015,
Right.
but not
So,
with what was indicated in
I think what the clerk and the assessor is both saying is if you're talking about 2013, then we would need to rule on the timeliness and allow it to be heard.
Okay.
If it's 2015, they'll go ahead and process it and we'll go ahead and hear it. What year are we talking about?
Well, can we first make a motion to hear for 2013?
Now, well, in effect, we could, depending on why it was filed 2 years late.
I will give you my good cause statement, which I believe if you've prepared yourself and read the appeal, I've laid out that argument very well.
Okay? In
And
effect,
if you'd like to take a moment to review it.
basically, in these timely issues, the evidence that you're showing here is why it wasn't timely in the documentation?
Correct.
Okay? Tell you what, give us a minute to just review all of this.
Thank you, Chairman.
get the whole packet.
I got it last night, read it.
Mr. Jackson, I think that everyone's read this. Typically, and I want to apologize to you, I didn't read that letter completely because typically evidence is not presented in the paperwork. What's in the paperwork is values, type of property, and that type of thing. So I should have read that. But in effect, now that I did read the letter, there's a few things that bother me as to there was no way I could have known or should have known that sentence that's in there. And then it is my strong belief and request that this appeal should be take into consideration 2011. Okay, I'm going to.
Before you go on, I think we should make it clear that you kind of gave him the option of declaring whether this was a 2013 or 2015, and he might be under the mistaken impression that that he could still deem it of 2015 if we hear it on the 2013.
Yes.
And we don't think that's the case.
It's not time. Even 2015 has gone beyond the filing date.
But if this were to be declared by him as a 2015, it would be timely. If it's being reviewed as a 2013, he asked, "Can we first do 2013?"
Right.
And the board kind of said, "Yeah, let's do that." But we can't really do that.
Right.
It's going to be, if it's a 2013, we're going to talk about timeliness. If it's 2015, it's timely, and that's fine. But if we talk about 2013 timeliness, then he's basically saying that this was a 2013 petition, which means that he didn't file a 2015 petition.
Right.
And he would now be trying to file a 2015 petition, and it wouldn't be timely.
I think in a sense, we now have the facts of this case. Would you like to add a little bit more to it?
How about this? Let's hear it on 2013 motion. I still have time to file for 15 that would be timely, correct?
To hear 2015.
I don't believe...
If I refile, a 2015 application would be timely.
No.
No.
That's what we're just coming
That's
to the
why
conclusion.
I
Well-
want to make sure that you were not given the wrong information by the board right now, because when they ask you to decide 2013 versus 2015, if we say that this was a 2013 and you want to know if it was timely, then that means that you didn't file a 2015 one, and that you would have to now try to file one and it wouldn't be timely. If you say that this is a 2015, as far as I know, it was timely for 2015, but it wasn't clear that it was 2015. The board has asked you to clarify which one it is.
Well, actually, the assessor and the board do not agree on the timing. He's already stated that he thought the application was 2013. She's clearly aware, because she's the one who sent the letter, that it's been amended to 2015, although the initial application was for 13.
And in effect, what it amounts to is that they've deemed it to be not timely.
Perhaps we need to swear the clerk in, because I feel like her statements are being sort of...
Where is the date shown on the application for appeal?
There is no date on the application. The indication of 2013 was his attachments, the letter that he sent with the application, saying that it's a 2013 application.
The next to the last paragraph of the taxpayer's letter says that the improvements at $156,000, not the 2015 evaluation of $185,000. These values are reflected appropriately on the appeal application. I think from that it's fairly evident that he was talking about 2015.
15. And the 2015 application is not timely.
It is.
It is. Yes. It was filed by November 24th.
Okay. Now,
And he did put the 2015 value as the value on roll on the application.
right. That, if it's timely, then we can go ahead and hear the case.
For 2015?
15.
Yes. If we stop asking if this was a 2013 and
Right.
allow him to say, never mind, I wasn't talking about 2013, which I think is what initially was meant by
Right.
this application, is 2015. But if we start talking about this as a 2013,
And it's
then
not.
he's going to probably lose on both years,
Right.
you know.
So,
In
we're
terms of
gonna,
timeliness.
we're gonna ask you, once again, is this application on 2015?
I believe that Ms. Erickson's already prejudiced the ruling there by stating that it is untimely. She said that twice now.
Well,
that
no,
it
I'm
would
saying-
be untimely
but
for
what I'm
13.
saying-
So my motion would be to hear this appeal for 2015.
Okay,
That's
go ahead.
fine, but I don't want to be considered to have prejudiced the board. What I'm saying is that you cannot use this one application for both 13 and
13,
15. You
right.
have to make a decision.
I should have filed multiple applications, I understand.
Okay, so, in effect, we're talking about 2015, right?
Yes, sir.
Okay? And then I can bring a motion to the board and ask them to make a motion, unless the board has additional comments you want to make or questions you have now. Nope?
Additional comments.
Okay. Then, I'll go ahead and entertain a motion to accept this application timely for 2015.
So moved.
Second.
Yeah, we have a motion and a second to hear this application for 2015. All in favor signify by saying aye. Aye. All opposed? Hearing none, carries. So we're going to hear your application when the clerk schedules it for 2015.
Thank you, Mr. Chairman.
Okay.
Thank you, Board.
I would like to make a comment to you that the council well knows that we are not intimidated by anything that she says.
That's true.
It's just a procedural issue is all.
Thank you very much. Thank you. Okay, that brings us to agenda item number 6, Beckman Coulter. I understand that application is a request for postponement. Is that correct, Madam Clerk?
Yes.
Okay. And do you have an idea of when it will be heard? What month?
I'd like to do it at the next hearing, so it'd be June.
Would be in June.
We have everything ready to go, just didn't work out to do it today.
Okay. In effect, this is a simple postponement. Do I hear a motion from the board?
I move that we accept the postponement on the Beckman Coulter applications for 2011, 12, 13, and 10. And we put it on the agenda for our next meeting.
June. Do we have a second?
Second.
All in favor signify by saying aye. Aye. All opposed? Hearing none, motion carries. So that will be postponed until June. Now, the agenda item 7 is a withdrawal. What is going on with agenda item number 8?
I did not receive a withdrawal form from them.
Can you enlighten us, Mr. Assessor?
Had no communication with them. So.
Okay. So in that particular case, we could deny for non-appearance.
If no one's here.
No one's here. Is there anybody here representing agenda item 8, Best Buy stores? I didn't think so. So do I hear a motion to deny agenda item number 8 for failure to appear?
I move that we deny item number 8 on our agenda, Best Buy stores, denied for non-appearance.
Have a second?
Second.
All in favor signify by saying aye. Aye. All opposed? Hearing none, motion carries. So that leaves us with the withdrawals and the withdrawal calendar. In that case, do I hear a motion to accept agenda item number 7, 9, and the withdrawal calendar as withdrawals?
I'll move to
Interesting, there's a
accept.
Best Buy stores on the withdrawal calendar. It's not the same application number, but it is a Best Buy's.
There was 2 Best Buys on the agenda.
Yeah, I know, I just thought it was interesting.
Oh.
One is we denied for non-appearance.
Appearance, and the other one is withdrawal.
Yeah.
So, do we hear a motion for withdrawals?
I'll make the motion. We accept items 7 and 9 and the March withdrawal calendar.
For a second?
Second.
Well, we have a motion and a second to accept the withdrawals as stated. All in favor signify by saying aye. Aye. All opposed? Hearing none, motion carries. Now, that brings us to the final item, and we do have a case that we're going to take in closed session regarding Lactus America Group. And other than that, I don't think there's anything else on the agenda.
And it looks like we're going to have to continue that because Mr. Morris is one of the panel members and there were only 2.
Okay, so we'll go ahead and continue our closed session until June. Now, is there any issue regarding the 2-year waiver? Or have they
No.
filed a 2-year waiver?
I have a waiver for them.
You have a waiver. Okay, good. All right. Then I'll ask, does anyone else have any further comments? Mr. Assessor?
No.
Staff? And board?
Mr. Chairman, I have, for the closed session, I was supposed to prepare some paperwork. Do you want me to hold that until the next time or to hand pass
Yes.
it out now?
Yes. We'll go ahead and hold it. There's no sense opening if we can't finish it.
Okay.
Okay, we'll just consider it in June. Okay, there is no further business on the Assessment Appeals Board, Tulare County for March 21st, and this meeting is adjourned.